Hello, thank you for joining us today. My name is Panayiota. I'm the lead property litigation solicitor at Debenhams Ottaway, and I'm joined by my colleague Penny Daisley, who is our debt recovery manager. We're going to be talking to you today about the recovery of rent from commercial tenants, in other words, tenants of business premises. There are many methods that can be used to recover rent from commercial tenants. We're going to give you a brief rundown of them. As to which method you might adopt, it really depends on a case-by-case basis, and we would assess all of them as and when matters arise. We will, however, give you some tips as to when we might prefer a certain approach. Now, I'll give you a quick summary of what we'll be looking at today, and then we'll get right on into it. The first thing that I'll be talking to you about is forfeiture of leases, and there's two methods of doing that. The first is by peaceable re-entry, and the second is by court proceedings. I'll then be looking at the commercial recovery of arrears of rent, the CRAR procedure.
And I'll be taking you through statutory demands and our fast debt recovery service.
And then to finish up, I'll be talking about deposits and guarantors and the Landlord and Tenant Covenants Act 1995. Now, getting straight on into it, we'll be looking firstly at forfeiture by peaceable re-entry. Forfeiture is basically a way of terminating a lease. It isn't strictly speaking a way of recovering rent, but it is a way of giving a tenant a short, sharp shock, which will hopefully prompt them into paying the money that they owe you. In order to re-enter premises by, in order to forfeit a lease by peaceable re-entry, there's certain things that you first need to check. The first thing is that it must be purely commercial premises. If there is any element of residential accommodation, then you wouldn't use the peaceable re-entry method. You would go via the court proceedings method, which I'll take you through in a moment. The next thing to check is the forfeiture provision in the lease. The standard provision in a commercial lease is that if rent is unpaid for 14 or 21 days after it falls due, then the landlord is permitted to re-enter the premises and terminate the lease. Another thing to look out for in that provision, though, is whether or not the rent has to be formally demanded. What you want to look for is are the magic words that the landlord can re-enter whether or not the rent has been formally demanded. If it's missing those words, then we have to go back to an old common law rule which requires a landlord to demand money at certain times and at very odd times, and including at sunset, before you can take any forfeiture action. Most leases will have the magic words in there, but do check to make sure that they're there. The other thing to check is whether or not the right to forfeit has been waived. You might ask yourself, well, how would that happen? I'll take you back to the forfeiture provision, which says you either have to wait 14 or 21 days before forfeiting. Once that period of time has elapsed, what you want to do is ignore the tenant altogether. If you take any steps that treat the lease as remaining in existence, so for example, writing to the tenant and requiring them to let you inspect the premises under the terms of the lease, then what you're doing is electing to treat the lease as still remaining in existence, and that would have the effect of waiving the right to forfeit. So what you want to do is, if those 14 or 21 days pass, check the lease provision obviously as to how many days you have to wait, and sit quiet, don't do anything, and don't warn them that you're going to send a bailiff in to forfeit, because if you do that, they may take steps to try and thwart you doing that. The last thing to check is the insolvency position. We're not going to be going into that in detail today. We will be doing a webinar on the effect of insolvency on landlords at a later date, so watch out for that. But as an example, if a tenant is in administration, so a corporate tenant is in administration, you can't forfeit the lease without the permission of the court or the consent of the administrator. So carry out the checks and make sure that isn't a problem. Once you've carried out your checks, you then instruct the enforcement agent and a locksmith, or the enforcement agent may instruct the locksmith for you. They'll set the appointment time, and it's usually very early in the morning or very late at night to go in and change the locks. The reason for going in very early or very late is that the re-entry must be peaceable, so in other words, no one is there. If it's not peaceable, it can't happen. So if a tenant is in occupation or sleeping at the premises, for example, even if they're not meant to be, then the bailiff or enforcement agent will not be able to peaceably re-enter, and the forfeiture can't take place by this method. What happens once you do actually manage to get the premises locked up and the keys handed back to you? Well, normally the tenant, you'll get a panicked telephone call from the tenant that day or the next day, depending on when you forfeited, asking you what on earth is going on because they can't get into the premises. At that stage, my response to the tenant would be, speak to my solicitor. And your solicitor should say to them, well, you haven't paid your rent, this is how much you owe, this is how much interest is due, these are our costs, pay everything and go off and apply to court for relief from forfeiture. Now, the tenant has to make an application to the court for relief from forfeiture in order to bring the lease back to life. It can't be done simply by agreement with the landlord. A problem that a tenant might have with that is that they won't immediately get relief from forfeiture from the courts. There is a bit of a process and it will take some time. So the tenant might be pushing you to allow them to come back into occupation quicker than that. Our answer to that could either be, no, we're not letting you in until the court's granted relief, or we'll allow you back in on a temporary licence pending the court granting relief from forfeiture. Unless you've got that temporary licence in place, then you mustn't let the tenant in beforehand, because you don't want, one, for them to lock themselves in and take back the premises, and two, if you do let them back in, you may be creating some other form of tenancy or some form of protected tenancy that you really don't want to do. Now, the tenant has at least 6 months to apply to the court for relief from forfeiture, and that is a void period for the landlord during which they're responsible for business rates, and of course they won't be collecting rent from the tenant. So that is something to bear in mind when deciding whether or not to forfeit. A landlord may want to relet the premises during that period, and my advice would always be not to grant a long-term lease during those first 6 months, but that if you wanted to allow a tenant to come in during those, a new tenant that is, to come in during those 6 months, to grant them a temporary tenancy at will, which could be determined if your previous tenant does apply for relief from forfeiture. So it is something to bear in mind. The tenant might not necessarily want to come back in, but they may do, and they have some time to do that. Now, in terms of costs, if you don't have a rent deposit, don't have a guarantor, and the tenant doesn't want to come back in, then you're probably not going to get your costs from the tenant. If, however, the tenant does want to come back in, then we would ask them to pay your costs. I'll turn now to forfeiture by court proceedings. You would use this if the premises are not purely commercial in nature, or if peaceable re-entry is not possible. Again, you want to check your lease for the forfeiture provisions, check whether the right to forfeit has been waived, and check the insolvency position. Then, instead of instructing the enforcement agent, what you would do is you would issue court proceedings seeking possession of the property on the basis that the service of the proceedings forfeits the lease. That doesn't mean, however, that once the proceedings are served, that the landlord gets the property back immediately. What happens is that the claim gets served on the tenant has an opportunity to put in a defence, and you will have a hearing in about 8 to 10 weeks' time after the claim is issued, at which point, if everything goes smoothly, the court will give you an order for possession, and only then can you re-enter the premises. Similarly to forfeiture by peaceable re-entry, the tenant can apply for relief from forfeiture, and if they do so, then we would ask the tenant to pay your costs, and likewise, where we were making a claim for possession on the grounds of forfeiture, we would also ask for the court to make an order that the tenant pays your costs. Now, when would you use forfeiture? I would use forfeiture by peaceable re-entry if a tenant is doing really well from the premises, they're trading really well, and they're just simply not paying the landlord rent for no other good reason other than they just think that they can delay. They will obviously be keen to get back into the premises so they can carry on trading. So this would give them a shock and hopefully prompt them into paying up quickly and teach them a lesson. I might also use forfeiture if other methods of recovery, so for example CRAR, has been successful in the past, but where the tenant just continues to default for no good reason. Turning now to CRAR, this is the Commercial Rent Arrears Recovery Procedure that replaced the common law remedy of distress. Before the CRAR procedure came in, we used to be able to send in a bailiff without notice to the tenant to seize goods from the tenant's premises and take them away and sell them. It would be the common law remedy of distress was effective because the tenants would get a shock. Now we have to use a procedure in CRAR, which I think is slightly less of a shock to the tenant because they're given notice, as I'll talk to you about in a moment. Now, CRAR can only be applied if you have a written tenancy of commercial premises only. If, however, there is someone residing in the premises unlawfully, then you may still be able to use it. You can only recover pure rent. You can't recover, for example, service charges and insurance premiums, even if they're reserved as rent by the lease. In order to adopt the CRAR procedure, you must also have a minimum of 7 days rent outstanding. That doesn't mean that the rent has to be outstanding for at least 7 days. It just means that there has to be an equivalent of at least 7 days rent due. The other thing to note is that the action can only be taken by enforcement agents. Now, the CRAR procedure, what happens is that you instruct the enforcement agent and they give 7 clear days notice to the tenant that they will be attending. The enforcement agent then usually attends at the premises between 6 AM to 9 PM, or if the tenant has usual opening hours beyond those times, then they can go during those usual working hours. They can only enter through a door or by usual means by which entry to the premises is gained. You wouldn't be able to go in through a window. When he does get in, the agent will hand the tenant a notice giving prescribed information explaining what's going on, and then takes control of goods by either securing them on the premises, removing the goods and securing them at another location, or by entering into controlled goods agreement, which is basically an agreement that the tenant will not move goods until everything has been paid. The enforcement agent then makes a written inventory of the goods, and within 7 clear days of taking the goods, he must provide a valuation to the tenant. The enforcement agent has to wait 7 clear days after the goods were taken before selling them, unless those 7 clear days would render the goods unsaleable. So, for example, if it's food and it just won't last that long, or if their value will be substantially reduced, then they can be sold earlier. And the enforcement agent has to give 7 clear days notice of the sale to the tenant. The goods must be sold at auction or otherwise disposed of for the best price that can be reasonably obtained at public auction. The downside to CRAR is that you only get fixed costs, and that's recorded in the legislation, and it's not full costs. Now, I might use CRAR if, for example, the tenant is a shop tenant and they have stock that's worth some money that would cover, we think, the amount of arrears. I would use CRAR for that. I would use CRAR if the landlord didn't really want to take on the responsibility of the premises and the business rates, which they would do if they forfeited. So CRAR is another way of showing a tenant that you're serious. Now, Penny's going to be talking to you now about statutory demands.
Thank you, Penny. Okay, so today I'm going to be talking to you about statutory demands as a means of collecting rent arrears. Firstly, what are they? Well, they're a form of a formal written demand that can be served by a creditor to request payment of a debt, so in effect your unpaid rent. You can serve a statutory demand on an individual or a limited company to request payment of rent arrears. It's a really good weapon in your armoury for the inexperienced tenant who will be quite frightened by receiving the possibility of insolvency proceedings against them. The first step is you need to know who your tenant is, as the process differs depending on whether you're dealing with an individual, partnership or a limited company. If you're dealing with an individual or a partnership trading as, then you would always take action against the individuals, not the trading as name. So for example, if it was Penny Daisley trading as Penny Sweet Shop, you would take action against Penny Daisley. If it was a partnership, for example, Penny Daisley and Stuart Love trading as Penny Sweet Shop, then you would again take action against the individuals, Penny Daisley and Stuart Love. If your tenant is a limited company, this is actually a form of business structure that is incorporated at Companies House. So in effect, it creates its own legal person. And in this instance, you would always take action against the limited company, not against the individual. So if I ran Penny Sweet Shop Limited, you would take action against the limited company and not me. And that's really important because the process will differ depending on whether you're dealing with a limited company or individuals. So for example, if you're dealing with individuals, your process would be to serve the statutory demand with a view to instigating bankruptcy proceedings if the demand wasn't satisfied. If it's a limited company, then you would serve a statutory demand with a view to instigating winding up proceedings if the demand wasn't satisfied. Okay, so once you know who your tenant actually is, the next step would be to draft the demand. Now, before you do this, it's important that you recognise that new insolvency rules came into effect on the 6th of April this year, and this has entirely changed the way things are done within the insolvency process. So previously, we would have statutory forms in which you would draft your demand, but now that's been done away with, and the requirements are detailed in Part 1 of the rules, and it sets out the information that should be included within the demand. This is really important if you tend to draft your statutory demands in-house and maybe working off some historic precedents, that you're aware that these may no longer comply as of the 6th of April. So what they've basically done is they've future-proofed the process of the insolvency proceedings, and it's really to reduce the amendments of forms to streamline the process. If you do draft the demand yourself, you can refer to the HMCTS website, which has some forms on there, which does contain the information that the new rules do require. But we would warn you to exercise caution. As a firm, we've noticed that there's been quite a few admissions on the forms of various legal stationers. So we would say in this early stages that you check against the insolvency rules, or you do actually refer to a solicitor to safeguard yourself in case you do need to progress with your insolvency proceedings. Okay, so once you've actually drafted your demand, or your solicitor has, you now need to press on with the delivering of the demand, which is known as service. Now, if it's an individual, it's important that you don't just pop it in the first class post, because if you do need to progress to bankruptcy, then you are going to need to prove to the insolvency court that you have served the document. So service is really crucial. You would need to hand it to them. You would need to try every single known address you have until you've been able to personally serve the demand on them. If it's a partnership with a principal office or a registered office, then you would need to hand it to a company director, a company secretary or manager, or in the alternative, you can instruct solicitors to get a process server to serve the demand for you. It's important that if you're arranging service yourself and you haven't gone through a solicitor, that you do keep a copy of the demand and you do keep details of service. Okay, so once the demand has been served on the tenant, they have various ways in which they can then deal with it. Firstly, they can apply to set the statutory demand aside within 18 days of service. This is usually if there is a genuine dispute, or if for some reason the form is invalid. So again, drafting is very important that it complies with the new rules. Or they can make payment within 21 days, which is ideally what we would hope for, or they can just ignore the demand and risk being placed into insolvency. If it's a limited company, then they can apply for an injunction to restrain you presenting the petition. That's obviously before the petition is issued. And again, the reason for that would be if there is a genuine dispute, or again, the demand is invalid. And it is important to emphasise that the dispute does need to be genuine. Okay, so in the event they do nothing, then you're entitled to proceed with your bankruptcy or your winding up petition, which is outside the scope of today's webinar. It's important to recognise that if you do go to this stage, you cannot guarantee payment, and in the event the company is wound up or the person is made insolvent, then you will need to you would rank with the unsecured creditors. Okay, so let's get on to some top tips. Right, so first of all, it's important to be aware of the value of the rent that you've got outstanding for you. So firstly, if it's an individual or a partnership, the bankruptcy limit is now £5,000. So you must make sure that the arrears amount to over £5,000. If it's a company, then it's lower. It's £750 before you can press ahead. So just check the amount that is owed before you issue the demand. Statutory demands are for a liquidated debt only, so you can't claim costs on it. So please don't add that to the demand. You would need to check your lease for any cost provisions to see if you're entitled to recover your costs. If the debt's secured, then you can't issue a statutory demand, and Penny will cover this when she talks about deposits later on. As we've touched on, it's not suitable for any kind of disputed debt. If the tenant can prove that the dispute was known to you and they make an application to set the demand aside, then you are at risk of an adverse cost order. So please exercise caution and make sure that there's no known dispute, known genuine dispute. Just a little reminder that insolvency courts don't like to be used as a debt collection tool, so always exercise caution with when you use these. And again, I would say it's a great tool to use for inexperienced tenant who will be very frightened by the prospect of these insolvency proceedings. Okay, so I'm just going to touch on our debt fast product. This is our fixed fee debt recovery product. I think when you're dealing with low value claims, maybe up to £10,000, it's very important that you have certainty on costs. And we use this debt fast service to offer cost-effective service for our lower value claims, volume debts. It covers all aspects of debt recovery to include issue of proceedings. So perhaps this, if your rent arrears is disputed, obtaining judgments, enforcement and insolvency. If you already have obtained a judgment, then we can enforce by the High Court enforcement officers, or a third-party debt order is quite a good tool to search their bank accounts to see if there's any money in there that we can potentially freeze, with a view to asking the court to release it to pay the arrears. We also deal with contested small claims on a fixed fee basis. So again, that provides you with certainty of costs. We're backed by a full team of litigation and insolvency solicitors. So we really are a one-stop shop here. Whatever you need, we will have somebody on hand that can answer your question or point you at least in the right direction. We do have a brochure on our website. If you can either put this address into your browser or just Google Debt Fast Brochure, Debenhams Ottaway, and it will give you more details of our service to include the fee structure. It's a service that we have many clients from different sectors. We can tailor make the service so it really does suit your needs. So if anybody wants more information on that, please feel free to get in touch.
Now, to finish up, I'll be talking to you about deposits and guarantors, and then the Landlord and Tenant Covenants Act 1995. Taking you first to deposits, this is a contractual remedy. You need to check the terms of the rent deposit deed if indeed you do have one, draw down the money and give the appropriate notice to the tenant in accordance with the deed. Now, a point to note on deposits and statutory demands and how they work in conjunction with each other is that you'll recall that Penny said that you can't serve a statutory demand in respect of monies that are secured. If you have a rent deposit deed, in my mind, that is security. So you have to be very careful about whether or not you can serve the statutory demand. As an example, if you have a tenant company and so your bankruptcy threshold is your winding up threshold is £750, and you have arrears of rent of £10,000 with a rent deposit of £5,000, I would only serve a statutory demand for the remaining £5,000, and I would be able to do that because I'm over the winding up threshold of £750. So really, deposits, if you want to draw down, just check what the terms of the deposit say and just make sure that you comply with that. In terms of guarantors, firstly, I'll be talking about guarantors which are not covered by the Landlord and Tenant Covenants Act 1995, and once we get to the Covenants Act, I'll explain what tenants that covers. What you need to do is check the terms of the guarantee and demand the monies accordingly. I would also consider serving a statutory demand on the guarantor if you've drawn down money from a deposit, you've then given the tenant notice that you've drawn down the money and that they're required to top it up, and the tenant then doesn't do so. I also think that's a bit of a nifty way to get around the security issue on the statutory demand, because if you draw down from the rent deposit deed, you then demand that the tenant tops up the deposit, which they don't do, you then don't have any security, and then you can serve a statutory demand on the guarantor, assuming that you've otherwise complied with the terms of the guarantee, and require them to pay the money, otherwise you will bankrupt them or wind them up. Now, this provision on guarantors relates to guarantors of the current tenant, so that's something to bear in mind. It doesn't apply to, there are special regimes under the 1995 Act for tenants that I will now take you to. Now, the Landlord and Tenant Covenants Act 1995 was introduced to resolve a problem that there was with the law, in that original tenants remained liable whether or not they'd assigned the lease, and that could mean that there was liability for many, many years. There are two categories of tenants or third parties that we need to look at. The first is in respect of leases entered into prior to the 1st of January 1996. Now, there probably isn't very many of those around in respect of commercial leases, and I certainly haven't come across one for a while. But if you do have one of these old leases and they have been assigned, then the original tenant remains liable to you as landlord, which they may not know about. Any intermediate tenants who've given you a direct covenant could also remain liable, and also the guarantor of any former tenant remains liable to you. If your lease was entered into on or after the 1st of January 1996, then the rules are slightly different, and this is probably now the more common situation. If the lease has been assigned, then the former tenant will only be liable if they granted an authorised guarantee agreement on the assignment, or if they've assigned the lease but the assignment was an excluded assignment under the 1995 Act, which it would be if it was an unlawful assignment. So, for example, if they didn't get your permission and that was required under the terms of the lease. Also, a guarantor of the former tenant who's given an authorised guarantee agreement and a former tenant who's been released because of an excluded assignment can also remain liable. So if you think that you have a very old lease, or you've got a new lease with an authorised guarantee, or another third party that may be on the hook, this is quite a neat way to try and get money if your current tenant is refusing to pay. What you need to do is go back to the lease, look at who the original parties were, look at when the lease was granted, and then take steps from there. What you must do, whether or not the lease was entered into on or after the 1st of January 1996, is if you want to demand money from one of those categories of people that remain liable, is that you must give a Section 17 notice in prescribed form to those people within 6 months of the date the rent fell due. If you miss that 6-month deadline, then that person will no longer be liable to you for those arrears. That doesn't mean, however, that they wouldn't be liable to you in respect of rent that fell due subsequently. So, for example, if you missed the 6-month deadline after the December quarter and they still didn't pay the March quarter, you could serve a Section 17 demand in respect of the March quarter, as long as you do that within the 6 months from the March quarter date. That would, however, only relate to the March rent, not also the December's rent. If, assuming you don't miss your deadline, you serve notice requiring them to pay, and if they do pay the money to you, so the former tenant thinks, oh, I'm on the hook now, I better pay, otherwise they could serve a statutory demand on me and bankrupt me, they'll pay the money and they will then be entitled to an overriding lease. That is a lease that sits between you and the current tenant. So you become the landlord of the former tenant or their guarantor, and that person then becomes the tenant of the current tenant in occupation. If they don't pay after serving after you've served a Section 17 notice, then you consider serving a statutory demand or issuing court proceedings against them. Now, I'm not going to go into this Act in any more detail because it can get quite complicated, but if you are in a situation where you have a former tenant or a guarantor of a former tenant that you want to go against, the best thing to do is make sure that you don't miss your 6-month deadline and then get some advice. And that could be a way of getting around a really difficult tenant who's just not paying you. Now, we hope that today has been helpful. Unfortunately, we don't have time to deal with any questions, but if you do have them, please do reach out to us via our website, and we'll do our best to answer as many questions as we can. And thank you for joining us today.